Okay, I'm just sharing my screen over here. Today's lecture is about comparative legal studies. There is echo. Okay.
No.
Okay, now. So basically, we have to understand over here that we are going to do comparison, which is good and which is not so good. Okay. And comparison of what? Comparison of law, comparison of legal systems, right? So basically, what is law? Law is a legal mechanism which is there to bring peace and order in society. And there are different laws depending upon the purpose, right? Over here, this is a comparative law. Comparative law means comparison between different laws from different countries, okay? Comparison of Nigerian law with US law, okay, or UK's law. So that is a subject matter of comparative law. Now, what is comparative legal studies? Let us understand. Comparative law is the study of foreign law, right? So it is a study of some foreign law. It is a comparison of law. Not really, it is a field of substantive law. So there is not a law book or not a law made by legislature on comparative law, right? For example, we have contract law, we have law of the constitution, but comparative law, it's not a subject or it is not a law made by legislature as such, okay? So it's not a substantive law. In what is substantive law? Which provides for sections and the rule. So there are no sections and there are no rules as such in comparative law, right? So it's not a substantive law. Comparative law is not a body of rules and principles. So guys, just follow the slides which are there on the screen and I'm explaining those slides to you. So yes, it's not really a field of substantive law. It is not a body of rules and principles. Primarily, it is a method, a way of looking at legal problems, legal institutions, and entire legal systems. Okay, so it is just a study approach. How you are going to understand your legal system and how you are going to compare that system with a system of some other nation. Okay, so it is a method, a way of looking at legal problems, legal institutions, and entire legal systems. Using that method, it becomes possible to make observations and to gain insights, which would be denied to one who limits his study to the law of single country. Okay, so if a study is limited to a single country, you will just know a law of your country, but you will not know whether it is a good law or it is not very good law. Okay, when you compare it with a law of some other country, you realize that we need to make some changes, and that's how it helps the law to grow. So laws, second paragraph, okay, in first slide, laws are evolved and developed in many ways. Comparing the laws of different nations or even cultures provides for a unique way to develop laws in a better manner. Comparative law is one such method which describes the comparison between different legal systems. There are two types of comparisons, micro comparison and macro comparison. Micro comparison refers to comparison between specific institutions or dealing with specific problems. Okay, for example, law relating to public interest litigation in Nigeria and law relating to public interest litigation in US. So this is a micro comparison. Then what is macro comparison? Macro comparison is comparison between legal systems in general, in totality. Okay, so there are two types of comparisons, micro comparison and macro comparison. Okay, I'm going to my second slide and I need it from John that I'm audible and visible. John, unmute yourself and tell me whether I'm audible and visible.
Okay.
Good?
I've done that.
Okay, so going to my second slide, just keep your eyes on screen, okay? So what is the origin of comparative law? Who started doing this comparison? The birth of modern comparative law is generally attributed to Europe. So, okay, so it started in Europe in the 18th century. That's what we know. However, prior to that, legal scholars, forerunners of today's comparativist and international lawyers, practiced comparative method. In Russian legal history, for instance, comparative method dates back to 16th century. It means it started in Russia in 16th century. We have Montesquieu. According to the prevalent view, Montesquieu is regarded as the father of comparative law. So this system started in countries long back, though it is not recorded anywhere. Countries, they have a habit of following each other's laws. Okay, for example, British law, it is followed in all the colonies, right? So we still refer their decisions. This is nothing but comparative legal studies. Next slide sheet. Next slide. What is there in comparative law? Okay, so now we know what is comparative law. Just compare between two laws of two different countries and see what this law says and what this law says and which one is good. Okay, so what is there in comparative law now? It is a comparative study of different countries. Okay, so comparative law is an academic study of separate legal systems, each one analyzed in its constitutive elements, how they differ in different legal systems and how their elements combine into one system. Several disciplines have developed as separate branches of comparative law, including comparative constitutional law, comparative administrative law, comparative civil law, okay, in like torts, delicts, contracts, and obligations, comparative commercial law, and comparative criminal law. Studies of these specific areas may be viewed as micro or macro comparative legal analysis, that is, detailed comparisons of two countries or broad-ranging studies of several countries. Comparative civil law studies, for instance, how the law of private relations is organized, interpreted, and used in different systems or countries. It appears today the principal purpose of comparative law is one, to attain a deeper knowledge of the legal system in effect. Okay, so to understand the legal system, and second, to perfect the legal system in effect. So, what is the purpose of comparative law? To get a deeper knowledge of legal systems in effect. Okay, so study both the legal systems or like many legal systems, okay, and understand them, and then perfect the legal system in effect. So try to improve your legal system by referring legal systems of other countries. This is done by so many countries in the world. Okay, now let us go to the next slide. What is there any example like how comparative law helps? So let us see some example of comparative legal studies. The foreign inspiration of number of legal rules or institutions is a well-known phenomenon, right? We all study laws from different countries and we refer it. For example, in Nigeria, British law is still referred, right? So this is comparative law. So focus on the slide, okay, I'm reading it. The foreign inspiration of a number of legal rules or institutions is a well-known phenomenon, sometimes so all-embracing that one speaks of reception, okay? So reception of a law in your country. Reception, for instance, of the English common law in the United States. In US, English common law is a base, okay? So English common law in the United States, Canada, Australia, India, and Nigeria, okay? So English common law is still referred or is still compared in United States, Canada, Australia, India, and Nigeria. Reception of a French law in French-speaking Africa, okay? So in a part of Africa, French law is still referred or it is a base for comparison. So reception of French law in French-speaking Africa, Madagascar, Egypt, and Southeast Asia. Okay, reception of Swiss law in Turkey, and reception of both German and French law in Japan, along with even some reception of American common law. So in Japan, German and French law is still compared with and along with US law. So the study of comparative law has found a special place in countries where such a reception has occurred. So see, comparative law, it's so common, right? English common law is referred in US, Canada, Australia, India, and Nigeria. Okay, so whenever there is a problem or when there is a precedent or judgment missing, this law can be compared with, right? And which law? English common law. It is welcomed in which countries? US, Canada, Australia, India, and Nigeria. Okay. French law, it's still compared with in which countries? French speaking Africa, Madagascar, Egypt, and Southeast Asia. Then Swiss law, it's still compared with in Turkey. Okay. And German and French law is still referred in Japan as a comparative law. So see, there are so many examples which you can gather from current legal systems. Moving on to my next slide. John, just give me a heads up about the audio quality. John? Mr. John, unmute yourself and tell me about the quality.
Yeah,
it's okay.
It's very okay.
It's very okay?
Yes.
Okay. So now let us come to a main point, like how comparative law is useful in African legal studies. Okay. So as we know, there are three major legal systems in today's world. Okay. And that is common law legal system, civil law legal system, and religious law legal system, right? Common law is a system which we got from United Kingdom or from Great Britain. Okay, so that is a law which comes from Britain or UK is called as a common law, right? So that is a common law. Second law we have is civil law. Okay, in other European countries like France and Germany, civil law is referred. Okay, and it has impact on various legal systems in the world. So one is common law, second is civil law, and third is religious law or Sharia law, okay? Or we call it Muslim law, which is applicable in lots of the countries in Middle East. So basically three legal systems are there: common law legal system, civil law legal system, and religious law legal system, right? Now, common law tradition is applied in UK, okay, USA, India, part of Nigeria. So basically all the ex-British colonies. You know that Britishers made colonies throughout the world, right? Britishers made colonies in Australia, they made colonies in India, they made colonies in Africa, they made colonies in US, okay? In US also Britishers, they had colonies before independence. In Canada. So all these countries, they still follow British law or common law legal system. Second thing is civil law tradition, which is applied in colonies of European imperial powers like Spain and Portugal. Okay, so Spain and Portugal ruled so many countries. They made their colonies in those countries, and those colonies or countries still follow civil law. Okay, so common law is followed in some countries, civil law is followed in some countries, and other countries or Muslim countries, they follow religious law, which is also called as a Sharia law. Okay, so in today's world, all the three legal systems are still there. Okay, all the three legal systems are still referred. Now, some countries provide a combination of all three. Okay, or combination of two legal systems. For example, South Africa. Okay, South Africa have all the three legal systems. Yes, John? John? Mr. John?
Yeah, yes.
Yes, you want to say something?
No.
Okay, you're good?
Yes.
Okay, perfect. So in today's world, three legal systems are there. And in some countries, a combination of legal systems is there. For example, South Africa, okay? In South Africa, they have a combination of legal systems. Got it? So that is the basic thing about today's study, that three major legal systems are there: common law legal system, civil law legal system, and religious law legal system. Common law system is still there and it is still followed in US, UK, part of Africa, India, ex-British colonies, okay? Civil law is followed in European imperial powers of Spain and Portugal, okay? And it has a Roman origin, so it is still followed in Germany, France, and other European countries. And then religious law in most of the Muslim countries. So that's the basic thing. In South Africa, there is a combination. Now let us see what is there in Africa. So which law is a base of African legal system? So I'm moving to my next slide. Just read the slide with me. So legal systems and comparative law in Africa. The laws and legal systems of Africa have developed from, just give me a second. Okay, developed from three distinct legal traditions. Traditional or customary African law. So in Africa, traditional or customary African law is there. Second is Islamic law, okay, or the Muslim law, or the religious law, and the legal system of Western Europe. Okay, so in Africa, it's a combination of common law, Islamic law, and traditional African law. In many cases, European or Islamic legal traditions have replaced or significantly modified traditional African ones. So in Africa, there is a combination of common law, customary African law, and religious law. So three legal systems are there in operation in Africa. In combination, it depends upon country to country. It is just an example. Okay, so I'm giving example of Nigeria. Example, the Constitution of Nigeria is the supreme law of the country in Nigeria. There are three distinct legal systems in Nigeria, which include English common law or customary law and Sharia law, okay, or the Muslim law. English law in Nigeria is derived from colonial Nigeria, while common law is developed from its post-colonial independence. So in Nigeria, it's a combination of three legal systems. One is common law, which is derived from Britishers or from UK. Second law is derived from customary law, the customs and traditions. And third law is Sharia law or religious law. I'm moving to my next slide. So now you know that comparative law is in between the countries. It is a comparison of different laws to see which law is better and how you can make your law better by getting example from other countries. Okay, so that is a comparative law. There is a micro comparison, there is a macro comparison. Okay, now next slide is comparative law is a method. Okay, so it is a method of study. It's not a different subject or different law as such. Okay, because there is this law is not like binding law. Okay, it is a method of study. This study is done by countries to make their law better. So comparative law is not a different subject or not a law made by legislature or parliament, but it's a method. It's a study method. So comparative law plays a significant role for not only international relations, but to understand legal systems as well. Comparative law is a method for the study of laws of different countries. It includes various processes such as analyzing the laws and comparing them on a different basis. Okay, for example, yes, John?
No.
Okay. I'm getting some disturbance, some echo type of thing. So please mute your earphones if possible. I'm hearing some sounds or echo. It's good now. Okay, so example, plea bargaining. Okay, so what is the idea of plea bargaining in US and what is the idea of plea bargaining in Africa, in Nigeria, in Ghana? Oh, it's okay. So that is comparative law. Example, public interest litigation. How public interest litigation is allowed in the US and how it is allowed in Nigeria or Ghana or Zimbabwe. Okay, so that is comparative method. Euthanasia, okay, mercy killing, law relating to euthanasia. Euthanasia is allowed in Spain now, right? So euthanasia was earlier banned, that mercy killing. If you are a patient, if you are in a bad stage of life, if you're going to die, if you are on an artificial support, then in that case, your relatives can can sign for a mercy killing or euthanasia to give you a relief from this life. Okay, so that law relating to euthanasia is allowed in Spain. So study of law relating to euthanasia in Spain and your country. So that is a comparative method. Okay, so that is a substance of comparative law, or that is the subject matter of comparative law. Next point, comparative law is not a body of rules and principles. Okay, primarily it is a method, a way of looking at legal problems, legal institutions, and entire legal systems. It's just a way of looking, like we solve theft, or we deal with theft or robbery in this way, how you deal with theft of robbery in your country. Okay, so how to deal with a particular problem. Okay, so that is discussed in comparative law. Using this method, it becomes possible to make observations and to gain insights, which would be denied to one who limits his study to the law of a single country. So if you just focus on your country, that this is our law, this law will not develop, right? When we see what is going in other countries, what is the law relating to euthanasia in Spain, what is the law relating to euthanasia in US, in India, if you compare between the countries, you can see that this law is better. We can borrow this rule from this country, right? So like that, and that's how comparative law is a method and it helps. Next point is, it's not a separate branch of law as such, right? Like you have a civil law, you have a criminal law, you have a religious law. So this is not a separate branch of law, right? It is comparison of civil law between US and Nigeria. It is a comparison of criminal law between Ghana and Nigeria. Okay, so it is not a separate branch, but it's just a method. It includes various processes such as analyzing the laws and comparing them on a different basis. It emphasizes on the legal mechanisms being adopted by countries and compares them. Example, death penalty and ways, right? So it just sees like death penalty is a punishment which is given in so many countries, right? As in some countries, it's hanging to the death, right? So it's hanging. In US, in some states, it's by electrocution. In some countries, a lethal injection will be given. Okay, in some countries, drowning is there. So same death penalty, same punishment, but it is given in different ways in different countries, right? So that is comparative studies. So it is not a separate branch of law, but just a method to analyze different. Please mute your earphone. I hear echoes. Okay, so comparative law is a way to build a foundation through which laws all over the world operate. The interconnectivity among the various sectors of different countries has created a situation where consensus between countries in various aspects becomes important. Next slide. So what's the use? It provides an insight into various political, economic, cultural, social, and historical aspects. Okay, so earlier, so I'll explain this slide without reading it, just listen. So earlier, as we know, historical school given by Savigny and some philosophers, that law was local, right? So so that school said that law should be local. Law is made for a specific country, so it should be provided as per the country's situation. You cannot take a foreign law from some other country and apply it to your law, right? Law should be local. It should come from your country. It should come from your people. But the new approach or critical legal studies say that yes, law should be local, but some problems are of international nature, right? So some problems are common in all the countries. For example, problem of rape, problem of theft, homosexuality, okay, euthanasia. These social issues are there in all the countries, right? So they are not limited to any single country. So every time you can't make a local law. You should see what is going on in other countries, and if possible, you can take a law from them and apply to your legal system, okay, for the better working of the law. I'm going to next slide. Okay, so just try to focus on the screen. So there are the methods. I'm just being very quick now. So first is functional method. Functional method deals with comparing the functions of the law that are in place. This method states that even if the structure of the law is different, but they have the same function and so can be compared, right? This is based on the principle that function of the law in any society depends upon the societal problems. And as the essence of such problems, it's similar, right? So problems in all the societies are pretty much same. And that's why function of law is also the same. So it compares laws on the basis of its function. I'm going to next slide. And next is structural method. This method is used to determine the similarity and differences between the structures of law. It focuses on the internal structure of the legal system and its core part. The structure of the legal system is analyzed and compared to determine the difference between the implementation of the law. This method helps in understanding the difference between how the legal systems have understood the same problem in different manners. Okay, so it is compared on the basis of structure. Next is analytical method. This is the most used method for comparative law. This method focuses on analyzing the meaning of different aspects of the law. It analyzes how the same concept can be understood in numerous ways. This includes the use of various terms in legal references such as right, liberty, cheating, defamation. So analysis of these methods is done. Next slide is cultural legal comparison. This method uses the cultural aspects of the nations for comparison. Every law and the legal system is based on cultural and traditional aspects, especially civil and common law. Thus, for comparing such laws, an understanding of the culture and host country is required. It might become challenging for a foreign person to analyze and evaluate the cultural aspects, right? For example, culture in Nigeria is different, culture in Ghana is different, okay, culture in South Africa is different. So you can't take a law and apply if your culture is not ready to accept the new law, okay? So in this case, that study of different cultures is also required. For example, federalism in USA and federalism in India. US is a federal country. India is also a federal country, right? So India borrowed federalism from US. We know that. So same thing, federalism. Okay, it is there in US, it is there in India. But same federalism, which is there in US, is not applicable in India, right? Because Indian society is different. India was ruled by Britishers, so it is more unitary. So yes, federalism is taken from US, from other country by doing comparative legal studies, but not the same federalism which is applicable in the US. In India, more powers are given to central government as compared to federal governments. In US, more powers are there to federal government, right? So comparison is done, comparative study is used, but some changes are also made while taking a law from a foreign country. So, and that is called cultural legal comparison. Next slide. So what is the significance or what is the importance of comparative legal studies? Let us go through it. Comparative law has evolved over the years and has provided for a very significant method to analyze the laws of other nations. It becomes important to analyze and understand the different ways in which the legal mechanism can be understood. The core part of every law around the world is based on the same principles of justice and equity. The execution and understanding of the laws becomes crucial, right? So number one function or significance is evaluating a better law. Comparative law helps in evaluating a better law. Okay, the comparison of different countries helps in analyzing the pros and cons of legal mechanism and reaching a middle ground for the smooth functioning of better laws. There are issues of liberty and discrimination which are not limited to one space or region, right? So these issues of discrimination, of lack of liberty are there in so many societies. And the application of such principles in other legal system provides for a new way of thinking and applying such laws in one's own country. These principles may not be binding on court of law, but they are used to compare and provide, okay? So this method is used by courts. If courts find that this law is not a very good law, then the courts can refer some foreign decisions that this is done in UK's court. So let us refer this decision, okay? So it makes your law better. Or if, so for example, if a new problem comes, okay, which is not a common thing, then in that case, You can take a law from foreign country, like what is done in US, let us do it, or what is done in France, this law sounds good in regarding euthanasia, so let us follow it, or let us compare both the laws and see which one is better. You can do that. So next part is gain knowledge. John, I'm audible? Just a quick thumbs up. I'm audible clearly? Okay. It is significant in gaining knowledge for students and professionals. It expands the horizon of legal mechanisms and provides for a chance to acknowledge the different aspects of the same offense or principle. Comparative law has caught the attention of both private and public international law, and thus it is also significant in analyzing the approach and methods for the relationship between individual and state and from state to state. For example, I'll give you an example. Crimes, okay? Crimes are there in every society. Okay, so crimes are there in Africa, crimes are there in UK, crimes are there in US. Okay, so but every country has different social problems out of which crimes are committed. Okay, in some countries, crimes are committed out of poverty. Okay, in some countries, crimes are committed due to extreme social stratification, a difference between rich and poor. In some countries, crimes are committed out of psychological problems. Okay, so every country has its different problems also. It's not like that in US there are no problems and in India there are problems, or it's not like that. Okay, so every country has its problems, and that's why you need a comparative studies. Next, it's substantiating. It helps in substantiating the application of the law. This is applied in Commonwealth countries as the laws are similar in these countries and the basic principles are also similar. The study of their legal system helps in substantiating the decision made by other Commonwealth countries. Even Nigeria follows the common law principle, and thus, in certain matters, the understanding of UK judgment becomes crucial, right? So, like a Nigerian law, a part of Nigerian law is based on common law, okay, or a British law. In common law, more importance is given to judicial decisions. Okay, so see, what is the main difference between common law and civil law? In common law, uh, more value is given to judicial decisions, or which we call it precedent. Okay, so precedent or a law made by judges is more important in Nigeria. Why? Because Nigeria follows common law legal system. In common law legal system, judges' decisions are more important. In civil law legal system, legislative law is more important. Okay, statute or law made by parliament. So in civil law made by parliament is the base. But in common law countries, law made by judges is the base. Okay, so that is the next thing, that is substantiating. I'm going to next slide. So next significance of comparative legal studies is improvement in legal education. Okay, so how it improves legal education? Let us understand. A comparative study helps in building analytical and comprehensive approach to apply legal mind. It helps in creating a distinction to the application of the law based on region and culture. And emphasis on such comparisons also helps in chalking out the new policies with better reach and implementation, right? So you can make your new policies depending upon the upon this comparative studies. Next, it's understanding international law. The most significant part of comparative law is the understanding of the international law. It not only it makes your understanding of international law better. So there are many international legal mechanisms and legal rules which binds different countries together for the operation of a particular aspects of society. Public and private international law, humanitarian law, the law of wars, international criminal law, international humanitarian law, and international refugee law are some of the basic parts of international law. The Outer Space Treaty was signed by many countries to regulate space exploration. The study of such international conventions and treaties helps in understanding the relation of different countries to such legal mechanisms. It also fosters better legal understanding between the countries, right? So study of comparative law gives a good knowledge of international law, right? So you study laws from different countries, you study international law made by United Nations, and it gives you a more and more knowledge of law. So that's how it is important. I'm moving on to next slide. Trade laws. So it is crucial for understanding trade laws. The comparative aspect helps for understanding of the trade laws in better way. So how a trade law is applied in this country, how it is applied in this country, how international trade relations are regulated. Okay, so without having full knowledge of legal aspect of trade relations will not be effective. Next is unification of laws. So what is unification of law? The main aspect of comparative law is the unification of laws on an international level. The comparative method provides similarities and differences in the legal system and thus helps in creating a uniform platform to come to a consensus on certain issue. It is an important aspect of economic legal cooperation. As the trade policies are crucial, the international trading system is sought to be made simpler with a comparative study. Okay, so sometimes it helps in unification of the law. Nowadays, as I told you earlier, some problems are local to a country, but the other problems, okay, are pretty much similar. Some problems are common in all the societies, right? For example, as I told you, so many things are there in every society. Problem of theft is there in every society. Rapes are there in all the societies. Then homosexuality, euthanasia, right? So these problems are there in, or these social issues. I won't say that these are the problems, okay? Social issues, they are common in all the societies, and sometimes study of comparative law can lead to unification of law or merging the laws or applying a same law in same country in lots of the countries when issue is the same. Okay, then I will conclude now. So let me conclude briefly. The comparative method has gained much attention in the law in the last 2 decades. The analysis of the legal systems and a better understanding of private and public international law proves it to be a crucial method. A comparative study is of such significant nature that it allows students and professionals to explore the inner structure of any legal system. This function further allows the minds to develop new laws and policies in a better manner by analyzing the existing legal structure of other nations and culture. On a global level, comparative law designs and fosters different aspects of law and questions about the various global and country level perspectives. So that's it for the day. I hope it helps. And yes, I'm done with my lecture. Yes, John, you can talk now. I'm done.
Okay, Prof, thank you so much for this wonderful lecture. So at this juncture, I think that our moderator is having problem in speaking, and I can see from that. So I'll just assist him for the meantime. So we are going to accept questions. There are a lot of people who want to ask questions. So you take in the questions and then you see what next. Thank you, Prof. So anyone who has a question should just show by hand and you'll be recognized by Prof. Thank you.
Philip, you have a question?
Yes, Kennedy, please go ahead and ask your question. Kennedy.
Kennedy?
Okay. Thank you so much, Professor, for this opportunity, and to you, moderator James. Am I audible enough?
Yes, your name is Naimbil Kennedy, right?
Yes, I'm
Yes,
Kennedy
I can
from
hear you,
Rockwood University. Okay, my main question, basically, I just want to get the clear difference between comparative law and international law, because looking at the explanation that Prof you've given, I can grasp some similarities between the two. That's comparative law and the international law. What's the major difference? As
very nice question, Kennedy.
Thank you.
See, I'll tell you what is international law. Basically, international law is a law made by United Nations, right? So after the Second World War, we all know what happened in Second World War. It ended when US dropped atom bomb on Hiroshima and Nagasaki, and lots of people, they were killed. So the world came together. All the countries decided that we should not allow the use of atom bomb because it's really bad for countries and it has a long lasting effects. Okay. So countries decided that we will come together and we will form an international organization. So lots of the countries in the world came together and they formed United Nations. Okay, so United Nations is an international organization, and law made by United Nations is basically called as international law. Okay, apart from that, European Union. Okay, so basically what is international law? Law made by European Unions, SARC. Okay, SARC countries, they came together, they formed their international organization. So when countries, okay, different countries come together and then they form their organization, and that organization makes a law that is called international law. So now you know what is international law. Now what is comparative law? Okay, example. If you study law relating to euthanasia in Spain and in Nigeria, that is comparative law. Okay. If you study law relating to primary education in US, in Finland, in India, and in Ghana, that is comparative law. Okay. So comparative law is not a law as such, but international law is a law. Okay. Because it is provided by General Assembly, which is a legislative body of United Nations. Okay, if it is made by European Union, it is provided by their lawmaking machinery. So international law is an actual law, okay, which is made for countries, but comparative law is a study method. Okay, for comparison, you can take a law from any country and you can compare. Okay, so basically, international law is a real law. Okay, though it is not binding, it is binding when your country signs the treaty, but still it is a law. But comparative law is not a law, it's a study method. Is that okay, Kennedy? I hope it helps.
Yes, I have gotten the clear concept. Thank you so much, Professor.
It was good. You agree with it?
Yes, I do agree, because where I was missing the concept is where I saw you brought in the aspect of international law within comparative law, of which I've seen that comparative law is just actually the similarities between laws of different countries.
And your question is really good, actually. You can use international law in comparative law. Okay, so you can compare your law with international law. Okay, so then it will be called as a comparative law. So basically, comparative law is a study method. And
okay, thank you so much, Prof. I have understood.
Is there any other question?
Yes, Prof. There is a question. I can see Mr. John. I will say your hand is, you've raised your hand. Please, can you go ahead and ask your question?
Yeah. Who is there?
Mr. John.
Mr. John, where are you?
Can you unmute yourself, Mr. John?
Okay.
And ask your, yes.
Yeah, can you hear me? Hello?
Yes, John.
Yeah, well, my question border on where you say evaluating a better law. Does it mean when the country creates a law and the law is bad and the other country should not adopt
Can
it?
you repeat the question? I'm not able to understand, John.
For instance, you mentioned evaluating a better law.
For euthanasia?
No, evaluating a better law. One of the significant of comparative study is evaluating a better law. For instance, when the country creates a law and the law is bad, does it mean that the other country should not adopt it? For instance, in America, where there is a homosexual law, does it mean the other country should not compare it with their own law? You getting my point?
Can you reframe your question? I'm not properly getting it.
My question, where you mentioned evaluating a better law, that is one of the significance of comparative study, legal study, is
Yes.
evaluating a better law.
Yes, yes.
For instance, where a country creates a law and the law is bad, and I make a reference to the America where there is a homosexual law, does it mean that the other country should not adopt the law?
Okay, so you are saying that if you want to refer US law on homosexuality in a court.
Yes. Yeah, the other country should not compare the law with their own law or adopt it, as the case may be.
So if you want to refer US law on homosexuality, and if you want to say in front of a court that this law is applied to US, and I want you I want you to refer that case, right?
Yes.
So you can make an appeal to the court. Actually, you can make appeal in a way that in our country, like in Africa, in lots of major part of the Africa, common law legal system is applicable, right? And US also applies common law legal system. So this law is made like this in US. So can we apply the same decision in our country? So you can make an appeal to the court, and then court will decide whether they want to allow it in a decision or not. Like in India, law relating to homosexuality of US is referred and it is legalized in India.
Okay.
Any other question?
Yes. Yes, Prof. You have another person. Please, Nkua, please, can you go ahead and ask your question? I'm sorry if I can't get your name correctly.
Who is asking me question?
My question is actually related to the previous question. I wanted to understand if I had understood the slides. If comparative law means that the courts are inclined to follow the better law, as you have indicated. So that is what I wanted to be clear on.
Yes, go ahead.
If the courts are inclined to follow the better law, for example, if the US law is considered better than the African law, and maybe let's say section of moral issues like the
may I know your name, please? I didn't see your name. Hello? Okay. So it's not like US law is better or African law is not good. It depends, like on a particular point, okay, which law is better for your country. You can study and you can decide and you can make appeal to your court of law. I'm not saying that US is correct or US law is a good law. It's not like that. Okay, take a specific point, for example, homosexuality, or for example, euthanasia, and see, okay, what US law says, what Nigerian law says, and then analyze which law is better for your country, okay, which suits your people. And if it is suitable, then only you should take it from other country. Are you getting my point?
Yes, Prof, we are getting you, but it seems we've lost her. She's no longer on the line because of bad
can you
internet.
give her this answer to her? This she is a good student. Actually, I like the question. So just give this answer to her, or ask her to watch the recording if possible.
Yes, please, we'll do that. Thank you.
Yes. So any other question?
Yes, please, there is. Ibrahim, please go ahead with your question.
Yeah. Hi, Ibrahim.
Thank you. Hi, ma'am. Ma'am, my question was regarding your slides whereby you stated one of probably the advantages of comparative law studies is trade laws. So it is crucial for understanding the trade laws between different countries. So once you're trading, if you're trading with another country on an international scale, you realize what laws they use, which allow you to, in fact, analyze what is happening in that particular country. But isn't it, according to my understanding of international law, one of the sources of international law being treaties? So once two or more countries sign treaties, don't those treaties actually incline what laws will be bound on them, and aren't those laws actually universally applied?
Yes, you're
That is my
absolutely
question.
right. If there is a treaty between two countries, then they should follow the treaty. Okay. And as I told you earlier, comparative law is basically not a law. It's not binding on anyone. Okay. Treaty obligations are binding. Okay. Treaties are actually international law. Okay. So if there's a treaty between Nigeria and Ghana regarding their borders or regarding their trade, things, that is a part of international law. Okay, and that is binding. It is a treaty. Treaties are binding. Okay, but comparative law is not a binding law. It's just a study method. Okay, you can study that whether this law is a good law, whether this law is applied with changes in some other country, whether we can borrow it. Okay, whether we can incorporate it, that law in our legal system. So that is comparative legal studies. Okay, so basically it's not binding. It is a study approach. Okay, just like critical legal studies. Ibrahim, is it like, do you agree? I hope it helps.
Yes, ma'am, I agree. Sorry, I wanted to add something that my question is also on the part of whereby countries they sign treaties. So those treaties actually tell them what they are supposed to be bound by, what laws they are supposed to be bound by as well. So doesn't that also cause a hindrance in understanding a particular law of a different country?
It depends upon the policies, basically. You are right. It might happen like that. But if it is binding, then they have to follow it. Though it causes some hindrance, still treaties are binding because it's mutual. Okay. So if they decide that this is binding on us and this is inhibiting our growth, they can ask for comparative legal studies to their scholars or their law department, and then they can make it better.
Thank you, ma'am.
Mm-hmm. You're welcome. I think questions are over. All right, Chakunanso or John or James. So,
John
Hello,
is
Prof.
asking question. John, I think John is asking question. Can you speak? John, I've voiced.
Hi, John. Yes.
Please, John, can you unmute yourself?
Okay. Hello, Prof.
Hi.
Where you mentioned that every country has its own problem, including Nigeria, including USA, America, and India. Every country has its own problem. That is why we need comparative law. In what sense can a comparative? Hello?
Yes, I'm listening.
In what sense can a comparative law help the country in solving their problem?
That's what, if you think that law relating to euthanasia is better in Spain, and if you think that you should get that law to your country, then you can do comparative legal studies and you can submit that report to the government that this law is better for our country. And if your government decides that, yes, we want to make it a law, then it can happen. So that's how it promotes scholars to go beyond their country's borders and take cognizance of some other law which is going on in some other countries. That's how it develops your law.
Particularly Nigeria at the moment are facing insecurity issue. What are the type of the law can we adopt in solving our security issue, insecurity issue?
So that is a country-specific problem. But yes, a study of comparative law helps in a way like you can try to change your policies on the basis of the comparative studies. Got it?
Okay. Okay. Thank you very much.
You're welcome.
Okay, Prof, I think there is a last question here. Nkua, please go ahead and ask your question.
Oh, I'm sorry, I got cut off while I was still asking a question. I don't know if it has already been addressed, but what I was saying before I got cut off is, as comparative law states, we're comparing laws to determine which one is better. So what I wanted to make sure I understood is, does this mean the country which law is considered to be less accommodative is inclined to follow the one it's being compared to, or is it every country's right to choose whether they are ready to accept and adopt the law to which it has been compared to?
Yes, it is. Basically, law is made by the legislature of your country. Okay, comparative method is just a study approach. Scholars can make a study that this law suits our country, and that whether to get that law in your country is a thing which must be done by your legislative body, okay, your parliament, and in which people's wish will be granted. What people from your country want, okay, what suits your country, which goes better with your country, or which considers your local conditions, which it will be decided by your legislators, okay, or your parliament or your legislative body. So that is the ultimate decision which will be taken by the legislative department, okay, where your people can ask your representatives to make a law. So it is upon the people and your country whether you want to accept some law or not. If people are ready and if the government is ready, that comparative law might help.
Okay, thank you.
You're welcome.
Yes, Prof. I don't think there are further questions, okay, unless I'm mistaken. Or Mr. John, you still have a question because I can see your hand is still raised. Or it should be considered as your previous hand. I don't know. Please, Mr. John?
No, I don't have any question anymore.
All right, thank you.
Okay, nice to talk to you, everyone. It was an honor, and I'm really thankful for all the organizers for inviting me to deliver a lecture over here. If you need any assistance in future, you can contact me anytime. Okay, and all the best to all the students for your bright career. I think that should be it, right? Goodbye.
Thank you very much.
Goodbye, Prof. Thank you for your time.
You're most welcome. Angie, thank you so much.
Thank you, Prof. Thank you, Prof. I really appreciate it. Thank you.
You're welcome.
Yeah. Bye-bye.